Welcome to UXL, where you can learn new skills anytime and anywhere. Visit uxl.com to explore our full course selection. This lesson is part of a larger course. Check the video description below for a link to the full course where you can enroll. If you enjoy our content, please like and subscribe. For your convenience, the course cover displayed on your screen provides the complete course title and lesson title. Let's proceed with the lesson. Lesson: California Harassment Laws and Prevention. California harassment laws are some of the most comprehensive and stringent in the United States, reflecting the state's commitment to fostering safe and respectful workplaces. These laws are designed to protect employees from a wide range of harassing behaviors, ensuring that all individuals can work in an environment free from discrimination and abuse. Understanding the intricacies of these laws is crucial for HR professionals, particularly those seeking to master the Professional in Human Resources California certification. California's primary legal framework for addressing harassment in the workplace is the California Fair Employment and Housing Act. FEHA prohibits harassment based on a variety of protected characteristics, including but not limited to race, color, religion, sex, gender, gender identity, gender expression, sexual orientation, marital status, national origin, ancestry, disability, medical condition, genetic information, and age. These protections extend to all employees, applicants, unpaid interns, volunteers, and contractors, reflecting a broad scope of coverage. Harassment under FEHA can take many forms, including verbal, physical, visual, and sexual harassment. Verbal harassment might include derogatory comments, jokes, or slurs. Physical harassment can involve unwelcome touching or physical assault. Visual harassment includes offensive gestures, displays of derogatory images, or inappropriate emails. Sexual harassment, a particularly prevalent issue, encompasses unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature. Notably, California law recognizes two types of sexual harassment: quid pro quo and hostile work environment. Quid pro quo harassment occurs when submission to or rejection of such conduct is used as the basis for employment decisions, while a hostile work environment exists when the conduct is so severe or pervasive that it creates an intimidating, hostile, or offensive work environment. One of the critical aspects of California harassment laws is the stringent requirement for employers to take preventive measures. Employers with 5 or more employees must provide harassment prevention training to all employees. Supervisors must receive at least 2 hours of training, and non-supervisory employees must receive 1 hour of training every 2 years. This training must cover a broad array of topics, including the definition and examples of harassment, the illegality of retaliatory behavior, and the employer's complaint process. This mandatory training aims to educate employees about their rights and responsibilities, thereby fostering a culture of respect and awareness. Furthermore, California law mandates that employers establish and distribute a written harassment prevention policy. This policy must outline the types of prohibited conduct, the mechanisms for reporting harassment, and the process for investigating complaints. Employers are required to disseminate this policy to all employees and ensure it is available in English and any other language spoken by at least 10% of the workforce. The goal is to ensure that all employees are fully informed of their rights and the procedures in place to protect them. In addition to preventive measures, California law imposes strict obligations on employers to respond promptly and effectively to harassment complaints. When an employer becomes aware of harassing behavior, they are required to conduct a thorough and impartial investigation. This investigation should be timely, involve interviews with relevant parties, and maintain confidentiality to the extent possible. Upon concluding the investigation, the employer must take appropriate corrective action, which may include disciplinary measures against the harasser and steps to prevent future incidents. Failure to address harassment complaints adequately can result in significant legal and financial consequences for the employer. Statistical data underscores the prevalence and impact of workplace harassment. According to the U.S. Equal Employment Opportunity Commission, approximately 85% of women and 15% of men report having experienced sexual harassment in the workplace. In California, the Department of Fair Employment and Housing reported receiving over 6,500 complaints of employment discrimination in 2019, with harassment being one of the most common issues. These statistics highlight the critical need for robust harassment prevention measures and effective complaint resolution processes. Examples of landmark cases further illustrate the application and implications of California harassment laws. In the case of Miller v. Department of Corrections, the California Supreme Court held that an employer could be held liable for sexual favoritism if it creates a hostile work environment. In this case, the court found that the pervasive sexual favoritism at the plaintiff's workplace had undermined her opportunities for advancement and created an intolerable work environment. This ruling emphasized the importance of addressing all forms of harassment, including less overt behaviors that contribute to a toxic workplace culture. Another significant case is Roby v. McKesson Corp., where the California Supreme Court expanded the definition of harassment to include discriminatory actions that are part of the employment process, such as performance reviews and discipline, if they contribute to a hostile work environment. This case underscored the interconnectedness of harassment and discrimination and the necessity for employers to scrutinize all aspects of their employment practices to prevent harassment. HR professionals must be adept at navigating these complex legal requirements to ensure compliance and foster a safe working environment. This entails developing comprehensive harassment prevention programs, conducting regular training sessions, and establishing clear reporting and investigation procedures. Additionally, HR must remain vigilant in monitoring workplace behavior and addressing issues promptly to mitigate risks and protect employees' rights. California harassment laws also intersect with federal regulations, such as Title VII of the Civil Rights Act of 1964, which prohibits employment discrimination based on race, color, religion, sex, and national origin. While FEHA provides broader protections, understanding the interplay between state and federal laws is crucial for HR professionals. For instance, the EEOC guidelines on harassment emphasize the need for preventive measures and effective complaint resolution, aligning closely with California's requirements. Moreover, HR professionals must stay informed about legislative updates and emerging trends in harassment law. For example, the #MeToo movement has significantly influenced public awareness and legislative actions related to workplace harassment. In response, California enacted several new laws, such as Senate Bill 1300, which expanded the scope of FEHA and made it easier for employees to pursue harassment claims by lowering the threshold for establishing a hostile work environment. In conclusion, mastering California harassment laws and prevention strategies is essential for HR professionals seeking to obtain the PHRca certification. By understanding the legal framework, implementing effective preventive measures, and responding diligently to complaints, HR can play a pivotal role in fostering a respectful and safe workplace. This comprehensive approach not only ensures compliance with legal requirements, but also promotes a positive organizational culture that values and protects all employees. This concludes the lesson. We trust you found this video informative and engaging. To enroll in the complete course, please use the link provided in the description below. At UExcel, we are committed to your learning journey. Each course offers a certificate of completion, online support, and downloadable resource files to enhance your experience. If you found our content valuable, we invite you to like this video and subscribe to our channel. Thank you for joining us, and we look forward to supporting your continued pursuit of knowledge.